can't hear a word. Sorry.
How many people are visible on live streaming? Is it just the two of you?
No, I think it's
yes. So you're not in the view.
oh, you're not, the pen is not in view.
Yeah, she's not.
Then you get a split screen, so I think Jonathan and I will be in it. I thought you were.
It just bounce that way.
And the call.
You check on YouTube as well to see.
I'm actually perfectly content not to be on it.
Oh, okay.
Arrange my close-up, Mr. DeMille.
Yeah. Last week's viewer figures, I think they hit 10 at one point.
Wow, the heavy hikes.
Yeah.
The sound isn't on yet.
It's in.
Sound's on. Not much interested in being horrid, but very nice call.
Didn't we do 3 in here? No, it was investing. Yeah. Because we had the little room just there.
We were sitting on the other side.
Hold in here. Keep you awake.
And appeal in the matter of commissioners for Her Majesty's Revenue Trustees and SSE Generation Limited.
Yes, Mr. Brennan. Morning.
May it please the court, together with my learned friend Miss Nathan, now herself Queen's Counsel, I appear for HMRC on HMRC's appeal. My learned friends Mr. Peacock and Mr. Ripley appear for the respondent taxpayer.
Thank you.
My lords, my lady, let's start with some housekeeping in this sense. I've discussed with my learned friend, we're listed for a day and a half.
Right.
It's our view that with a fair wind we should finish today.
We won't object to that at all.
I've never been criticised by a court in those circumstances, and I don't expect it to start now. There are 2 applications before the court for permission to rely on very slim, unagreed bundles. Again, I've discussed those with my learned friend. He has no objection to the, I think it's only 17 pages of illustrative diagrams and photographs in mine. I have never had any objection to similar documents in his. I maintain a muted objection to him relying on the witness statement of his main witness, who gave evidence and was cross-examined before the first tier tribunal. There is no irrationality challenge, no Edwards and Bairstow appeal, and it is in my submission wrong in principle for the court to start examining the carefully drafted evidence in chief of the witness at this stage of the proceedings. And if I can put it like this, I don't want to get into the situation where the judgment eventually comes out with a sentence in it, Mr. Peacock relied on the witness statement of Mr. Smith without objection from Mr. Brennan.
You do object, yes.
Yes,
but we have that.
perhaps we can look at it, if it really matters, we can look at it when it arises.
Yes. Very good. Can I raise a matter of housekeeping with you? We thought that this is a sort of case where a transcript would be helpful. I don't know whether the parties were going to have a transcript anyway, but if you were prepared to share it with us, we would be extremely grateful.
Your Lordship means a transcript of this appeal?
Of this appeal, yes. But
well, we'll certainly investigate.
Thank you very much indeed. That would be helpful. Thank you.
The appeal, as the court has seen, aims to examine the boundary drawn by legislation in 1994 and consolidated in 2001, in which Parliament tried to draw what the Minister described as a line in the sand, so as to clarify and strengthen the boundary between buildings and structures on the one hand and plant on the other for the purposes of capital allowances. I'll take the court to that short Hansard extract, not in a pepper and heart kind of way, but in order to identify the mischief at which this legislation was aimed in due course. You have seen that we are concerned with very substantial long-term infrastructure assets for use in producing electricity, literally on an industrial scale. There are water collection assets. The water is taken in from the mountains high above Loch Ness. We are not concerned, because I lost before the first tier tribunal and am not appealing that point, with the intakes to the pipes, etc. There are various sluices and filters and siphons, some as small as a garden ornament and some enormous. And we're not concerned with those. The first tier tribunal held, and it was an available conclusion, although disappointing, that those had a sufficiently plant-like character and weren't disqualified by any of the express disqualifying provisions. Moving downstream, we are concerned with what you might very loosely call pipes. Some of these are simply enormous, blasted through the rock. There's something which you'll see on a plan in due course called an aqueduct tunnel, which is 6 kilometres long, blasted through the virgin rock and carries very large quantities of water downstream to the reservoir. There is a channel constructed from reinforced concrete, again on a scale which the Faroes would envy, and in a man-made trench. You'll see a photograph of that if you haven't already. There are trenches, simple trenches in the ground, lined with stone or concrete, which carry water into the reservoir, and so on. And the question for the court, we're still upstream of the reservoir, will be the extent to which there was an error of law in the tribunal, or when it remade the decision in the decision of the Upper Tribunal in the categorization of those assets. The terms which we view with particular enthusiasm are tunnel. A tunnel is disqualified, and aqueduct. An aqueduct is disqualified. One of the ways in which my learned friend succeeded before the Upper Tribunal, having had a different result at first instance, was in satisfying the Upper Tribunal that in the context of this legislation, a tunnel must have some form of transport function, and an aqueduct must be that restricted sort of aqueduct that looks like a bridge. Obviously, as everybody accepts, there are other sorts of aqueduct, but the Upper Tribunal saw fit to decide this case on the basis that what I argue to be aqueducts were not aqueducts because they didn't look enough like bridges. The water goes into the reservoir. It comes out of the reservoir, operated remotely by a control room in Perth, and flows down the headrace tunnel. My learned friend says it's not a tunnel, so when I refer to it as a tunnel, you will always bear in mind that is controversial in this context. The headrace tunnel is 6 kilometres long, and it has a vertical fall of about 600 metres. At the top, it's 5 metres in diameter. Just to pause and think about that for a moment. I looked it up. The diameter of the central line, which is cylindrical Chancery Lane, is 3.5 metres. This is 5 metres wide. Remembering that we're looking at the square of the radius, the cross-sectional area of the headrace tunnel is twice that of the central line tunnels. The water comes down that through a fall of 600 metres. There's a late tapering of the channel to something, I'm going from what it looked like, maybe a metre or less, with steel reinforcement for the last 200 metres of its journey. And the water then flows into the hydroelectric turbine at simply enormous pressure and speed. It's used to generate electricity when it's needed. It's switched off when it isn't needed. And then the water flows out down the tail race tunnel, no longer under pressure, and is exhausted into Loch Ness. We have before you, on these aspects, 7 points of appeal, which I persuaded the Upper Tribunal each gave rise to important points of principle, because this is a second appeal. And so we have permission from that tribunal and not from this court. And then there is a separate, as we would categorise it, important point of practice, whether my learned friend's clients needed permission to appeal on one particular point from the first tier tribunal to the upper tribunal. It's common ground they did not seek permission to appeal and therefore didn't have it, either from the first tier tribunal or from the upper tribunal. The upper tribunal decided the point on the basis that they didn't need permission to appeal, and I wasn't prejudiced by them in entertaining the point. My point is not based on prejudice, it's based on the law. My point, which I will obviously develop briefly shortly, is that that matter was simply not before the upper tribunal. It did not have jurisdiction to determine it against us. My submissions will seek to apply this detailed legislative code to the facts. I'm not going to reply in advance, but I want to make this comment about my learned friend's approach as disclosed by his skeleton argument. He relies significantly on other statutory provisions addressing different mischiefs in different contexts in order to find some support for his position on, say, aqueduct, tunnel, and so on, from those provisions. Our position is that we identify the particular statutory code and seek to apply it to the particular assets, in knowledge of and with full regard to what we know, because Mr. Dorrell told us, to have been the parliamentary intention. And that parliamentary intention is very significant when one looks, this is a preview of a point which will make, I'm sure, more than once. When one looks at the peace argument, which found favour before the upper tribunal. So the upper tribunal took the view that some of the disqualifying provisions addressed only transport assets. There is absolutely no clue anywhere in the statute, apart from the grouping of those assets, that Parliament had any intention to limit the disqualification to transport assets. It has been dreamed up because the word aqueduct comes close to the word bridge, for example, in the first group of disqualifications which we're going to look at. But nobody, the Upper Tribunal, has not engaged with why this limitation, which I have described in writing as eccentric and unexplained, should have been adopted by Parliament, given that we know what Parliament's aim was, namely to draw the line in the sand so that the litigation which, for my sins, has occupied me for a professional lifetime could be brought to an end. And when we do go to Mr. Dorrell's observations, I'll draw your attention to what a Member of Parliament said in a question to the Minister about something with his own clients, about a car wash, and I'll explain that when we get there. And you'll see why. You'll see that as an example of why this legislation.
We may have to be careful how far we go into parliamentary debates.
I fully accept that, my Lord. I've already made.
I mean, I understand the point about the mischief.
Yes. Yes.
I'm not sure it's really going to be right to go much further than that.
I do not seek to go further than mischief. I was on the wrong side in Pepper and Heart as well.
Oh, right.
And no, it's not a Pepper and Heart point.
No.
So may I invite the court to look at the legislation? I hope you will find it in the authorities bundle behind tab 3. It's been, I hope, usefully highlighted, and I'm just going to skate over the highlighted bits which track what one needs to look at before one gets to section 21. So we know it's a qualifying activity, it's a trade, it's qualifying expenditure if it is capital expenditure on the provision of plant. It could be plant or machinery, but we are not here concerned with machinery. I shall refer only to plant. So a trade is a qualifying activity. We get that section 15. And qualifying expenditure is to be found, it's in the authorities bundle at internal pagination 32. And in the 2001 Act, consolidating provisions introduced in 1994, we get section 21 first. So the first thing Parliament does is disqualify buildings and provision, so expenditure on the provision of plant, 21.1, does not include expenditure on the provision of a building, and provision includes construction. That's something that we'll see again. And then it's necessary to define building, so assets which are incorporated in the building or are, broadly speaking, the sort of thing you find in buildings or fall into the list of assets treated as buildings. And then there's flags up a carve-out, we'll see in detail in section 23. You don't need to spend time on buildings. That was in play below. I had a point about buildings relating to the Catalans, which were excavated in the virgin rock and contain the turbine hall and other assets, but it's not in play.
Yep.
Section 22 is extremely important.
Yep.
So, for the purposes of this Act, expenditure on the provision of plant does not include expenditure on A, the provision of a structure or other asset in List B, or any works involving the alteration of land. Now, I'm afraid I'm going to succumb to making this point more than once as well. Those are two disqualifying provisions. If, subject to the savings, which we're going to see in List C, if something is disqualified by 22(1)A because it's a structure or other asset in List B, then it's disqualified. But if it survives List B, it may still be disqualified by 22(1)B. The first tier tribunal said that those provisions are largely mutually exclusive. I'm not sure what can be meant by that, because if something excludes something else, it either excludes it or it doesn't. It doesn't partially exclude it.
Well, I thought, as I understand it, what they meant by it can be in List B, even if it's not excluded from the general rule as a result of being in List B. So that was because they effectively treated things that are in item 7 of List B as being in List B, even though they were not excluded by List B.
Well,
whereas what you say is that if you don't come within A, i.e. you're not excluded from the general rule by being in List B, it doesn't make any difference that you are specifically carved out of List B. You can still fall within 1B.
Certainly that. List B, and let me come to it now if I may, contains 7 categories of exclusion. The 7th category has savings from the exclusion. But item 7 is still a further exclusion on top of items 1 to 1. Now we're going to have to look at item 7. But the argument which has appealed, as we understand it, to the Upper Tribunal is that something which is saved from item 7 and is therefore not disqualified as being something in List B cannot be disqualified by 22(1)B. And that, I submit, is a straightforward error. And this may be what the first tier tribunal meant by saying, well, they're largely mutually exclusive. Things will not often fall both within List B and within 22(1)B as it works involving the alteration of land.
Well, most of them would, wouldn't they? I mean, most of the things in List B do involve the alteration of land.
Well, they do involve...
So, I mean, in that sense, they're not mutually exclusive at all.
They do involve... They will require...
I mean, if you build a tunnel or a bridge or a viaduct or a dam or a railway or a road, you're almost certainly altering the land.
You're altering land, but the nuance is slightly different.
Right.
22(1)B is aimed at alteration of land so that the altered land functions as plant. The head race, in our case, is a super example of that. This huge cylindrical hole 6 kilometres through the rock. It is that alteration of land.
Yeah, well, I understand that, but I mean, isn't that true of A and B? I mean, it can be before you're excluded from being plant or machinery. I mean, you start with the presumption that it is plant and machinery.
Yes.
I mean, this may be partly clarificatory, of course. So it may be just making sure people understand that. But I mean, I mean, but the point you're making would apply to A as well as B, wouldn't it?
Well, there will often be, if not, as your Lordship points out, if not always, there will be some alteration of land involved in constructing those structures.
Most of them, yeah.
And some of them will be little else. Look at, if you would, item 6, last words, a drainage ditch. There's not going to be much to a drainage ditch in addition to the alteration of land. Indeed, we've got what you might loosely call drainage ditches involved in the assets in our case, the open trenches that feed into the reservoir.
But does provision of the structure, which includes construction, we're told in subsection 2, also include renovation as part of construction? So one could fall within that definition if you were renovating a dock, let's say, which wouldn't necessarily involve any alteration of land.
Well, the question will be, are you providing the structure? You will have to incur capital expenditure, so you're not just repairing something you already own. I hesitate, without more time to think about it, to say that you are providing the structure if you renovate something you already have. Perhaps I could return to the point. If it still seems important.
There may be some quite fine distinctions between renovation and construction,
Well,
if you're right about that.
And I mean, this is famously an area of law in which fine distinctions have been drawn in many, many of the cases.
Yeah. Thank you.
But I was making with some warmth my point that 22.1a and 22.1b are both exclusions. So that even if you survive being excluded by 22.1a, for example, because you don't fall within 1 to 6, you would fall within, well, do fall within 7, except that you are carved out by 7a as an industrial building, for example, in our case, used in a trade of electricity generation. So that you survive list B. The approach which found favour with the Upper Tribunal was to say if you've survived list B, you don't have to look at 22.1b. So that they've treated them, those provisions, as qualificatory in character, not disqualificatory in character. So that if you get through one gateway, it doesn't matter whether you can't get through another gateway because you've reached the destination.
Well, so you say what you're complaining of is that you think that 1b also includes the provision of a structure or asset if it's not caught by list B.
It catches any works involving the alteration of land. So the head race will...
But I thought it was, is it accepted that you can't split the work? Because I thought that one of the problems that we both had with how they dealt with the cut and cover conduits, where they said, well, the excavation work is on one side of the line, that the cover, that the actual making of it is the other, that then led to part of the expense being allowed, but part not. But are you saying then that if you are the provision of a structure or other asset and you're not included in list B, you're not you're not excluded from the general rule by being within list B, then what then is caught by B? A subset of the expense or all the expense? Or
If the asset is not disqualified by list B,
yeah,
either because it is not a tunnel, bridge, etc., or if it is some other structure but falls within the carve out in item 7.
well, it would have to, because item 7 covers any structure that's not in items 1 to 6 except that.
Yes,
So-
forgive me. List B doesn't only catch structures; it catches structures and other assets. So that the heading to List B
Yeah.
is excluded structures and other assets. So, in a loose sort of way, you might say that a drainage ditch is a structure. It probably depends on its actual construction. But you wouldn't very naturally say that a ditch was a structure. But it doesn't matter because it's expressly excluded by virtue of falling within List B.
So are you saying then that there are things which are assets, which are not structures, which do not then fit within any of 1 to 7?
There may be. Not in our present case, on my analysis of it. My learned friend asserts that the assets are all structures, but I would dispute that. For example, the head race is not, I would say, a structure. It is a void.
But then how can you accept that it's an industrial building?
I don't accept that it's an industrial building unless it is a structure. So if it is a structure, and this is how it's recorded in the first tier tribunal decision, if it is a structure, then it falls within 7A as being used in the trade of electricity generation. But my point about the head race is that it's disqualified as a tunnel or an aqueduct and an alteration of land anyway. So it's disqualified by List B under at least 2 headings. I don't need to show that it's some other sort of structure. But if it is a structure which isn't within 1 to 6, then it is saved by 7 because it's used in a trade of electricity generation, and so it would be an industrial building.
But just getting back to my question, if something is a structure or other asset which is not excluded by List B, and you then have to consider, is it excluded by 22(1)(b), is the exclusion from 22(1)(b) in relation to all the work or only a part of the work, the part that involves the alteration of land?
The disqualified expenditure is the expenditure on works involving the alteration of land. Now, you might have to ask a quantity surveyor what expenditure is fairly attributable to the alteration of land. Do we have to have the architect's drawings or some elements of ancillary expenditure? But the disqualified expenditure is the expenditure on the works involving the alteration of land.
So to take an example, supposing that a mobile phone operator wants to erect a mast, substantial mast, freestanding mast, in a field. It needs to construct a concrete base for it. On the face of it, the construction of the concrete base would seem to involve the alteration of land.
Yes.
So it does that as a building contractor who does that work. It then acquires the mast. Perhaps it arrives in segments on site. It's very tall, and work goes on to assemble the prefabricated parts to erect this very tall mast, which is then anchored onto the concrete base. So would the acquisition and installation of the mast, which becomes the property of the mobile phone operator, would that fall within, quote, works involving the alteration of land?
May I give you two answers?
Are they going to be
no,
contradictory?
Two answers, both leading to the same result.
Right.
Where the groundworks are ancillary to provision of the main asset, we would say that the installation cost is part of the cost of provision of the asset.
So when you say the installation cost, do you mean the construction of the concrete base?
I was using the term loosely.
Right, yes. So you would say
digging the hole and putting the concrete in.
So construction of the concrete base is part of the, what did you say?
Provision of the structure.
The provision of the structure. The structure being the whole assembly, both the base and the mast.
Yes. And so, and I haven't yet come on to my second way of putting it.
Yep, no, fine.
And so, the mobile phone mast is saved by List B, Item 7C.
I follow. But it's not within List B because of that. Because of the exclusion, the exception, if you like.
Yes, and the alteration of land
Yes.
is ancillary to the provision of the structure, and so it's not disqualified by 22(1)(b). But in any event,
why is it?
So
not
yeah, just
disqualified?
so yes, why?
there are two reasons. Provision of the structure, in my submission, connotes buying, assembling that structure and installing it, where the installation, the base, is ancillary to providing the structure itself. But even if I'm wrong about that...
But sorry, if you're right about that, why does that mean it's not excluded? Because that's part of list... That then is part of what falls within Item 7C. So it's not excluded by being within List B.
Correct.
So it's not allowable.
No, it's not excluded.
Right, so then you have to go on to
B.
apply
It's not.
B.
The question is, yes. So to get it straight in my mind, because my example comes within 7C, it is not, it's not excluded by being within List B.
Correct.
Because it's taken out of List B by C. That's the sort of first step. So then my question was, well, does it therefore come within little b? Because you say, well, the next question is it within little b?
Yeah.
And I'm not quite clear what you say about that.
Right, I'm still trying to give the court two answers to that.
Yeah.
One is the one I have given, which is that digging the hole and putting the concrete in is part of provision of the asset. But if I'm wrong about that...
Well, so just pausing there. Can we pause there? So I think what you're saying is that in the circumstances I've described, there's one provision going on, and that's the provision of the telecoms mast comprises both the construction of the concrete base and the acquisition and erection of the mast on it, and that's a single operation. So it does involve the provision of plant or machinery. I mean, I think you accept that. Prima facie common law, this would be plant or machinery. But it does. But those are what I've described. The totality are, quote, works involving the alteration of land.
The installation work is works involving.
Well, I want to pause you. What do you mean by the installation?
Digging the hole, putting the concrete in.
That I understand, but what about the acquisition and erection of the mast and its anchoring into the concrete base? Is that a separate thing?
I would say that that's not alteration of land.
It's
But
not.
but
It's not. Well, the question is it works altering that? I mean, I understand why you say it's not altering land. And what, in order to come within B, it has to be works involving the alteration of land. So I think you're probably, aren't you, dividing this into two? You're saying, first of all, you've got the construction of the concrete base, and those are, I mean, one would have thought clearly works involving the alteration of land. But you're then, so you couldn't claim that. I mean, subject to whether it comes within List C, which is another matter, of course. But on the face of it, if we were just looking at this, you couldn't claim the cost of constructing the concrete base as a capital allowance. But you say, well, but the acquisition and installation of the mast is separate, and you could claim that as a capital allowance.
Yes, I would say that acquisition, erection and so on of the mast and its concrete base is all of a piece with provision of the mast. But if I'm wrong about...
But sorry, just to pause you there, I really am concerned, Mr. Brennan, about that, because if you lump them all together as a single item, including the construction of the concrete base, then you have got works. I mean, in that total mix, you've got works involving the alteration of land. I mean, or are you saying, well, yes, it is one, but there's only one bit of works in there, which is the construction of the concrete base? I mean, I'm just not quite clear at the moment on this. I mean, would the mobile operator be able to claim a capital allowance or not? I suppose is the basic question. Just forget about List C, just looking at this.
My position is yes, he would,
right,
because the works involving the alteration of land are ancillary to the provision of that qualifying structure.
So then you do accept that they are mutually exclusive to that extent. But I thought that you disputed what the FTT and the Upper Tribunal...
I don't accept that they are mutually exclusive.
Sorry, let me see if I can...
Can I just, before you do,
yeah.
You said that the works are ancillary to, I just didn't quite get the phrase, qualifying something you said, I think. I just wanted to get that.
Something to the effect of installation of the qualifying structure.
Thank you. Thank you very much. I'm sorry to interrupt.
No. So, as I understand it, what you're saying is, when you're applying List B for the purpose of, or looking at what's called by List B for the purposes of 22(1)A, you have to look not only at the structure itself, but the ancillary work, as you've described it, right? So that I think you're accepting that what's covered or saved by item 7C is not simply the structure or the telephone mast itself, but the work of digging the hole and putting in the concrete base. So that all comes out of List B. Because it's saved by being in 7C, and therefore it all is not disqualified from the general rule by 22(1)(a). Right. So then, what the Upper Tribunal said is, well, that's the end of the question, because you don't go on to 22(1)(b), because that's only works that don't involve a structure, right? But
Yes.
I understood you to be contesting that and saying, no, the whole thing, all the work involved comes out of 22(1)(a) because it's saved by item 7C, and then you have to apply 22(1)(b) and disqualify any works involving the alteration of land.
Yes.
Right. Now, they regarded that as proving that your construction was wrong, because they said, well, that can't be right, because then everything that's in 7A, 7B, 7C would be brought back in, and Parliament clearly intended to allow capital allowances for that. My question, which set us on down this path, was, well, how much of everything that's saved by 7C could possibly be excluded alternatively by B? Is it just the excavation work, or is it the whole construction? To which your answer is, well, the excavation work is ancillary to the structure, but I don't know how that answers my question. Are you then saying, well, because it's ancillary, then all the expense that's covered and saved by item 7C then is work involving alteration of land, and so is excluded by 22(1)(b), even though it appears Parliament wanted you to be able to collect an allowance, or only a subset?
This discussion, with respect, omits consideration, as Lord Justice David Richards has steered me away from it several times, of List C.
Yeah.
Because item 22 of List C is there for this purpose.
Yeah.
So,
That's what we were
yeah.
expecting you to say, but you seem to be, I was expecting, but you seem to be putting forward that as a second string to your
Yes.
bow, whereas I didn't understand what the first string to your bow was.
It is the second string to my bow. My first string
Yeah.
is that where you have a structure which requires what I think I've already described as ancillary groundworks,
Yeah.
then the groundworks, the cost of the groundworks is part of the provision of that asset. It may be very substantially driven by questions of scale.
Yeah.
So if the groundworks are enormous and enormously costly, and the asset is quite small and cheap, then you might say, well, what's really happening here is that there are works involving the alteration of land and a small cheap structure. You can have the cost of the structure, but the alteration of land is disqualified by 22(1)(b). But while this discussion is helpful in illuminating List B, it ought not to obscure or ignore the existence of item 22 in List C, because that solves the problem. So when the officious bystander says, well, hang on a minute, here's a telephone mast, but you're digging up the land, that's an alteration of land. The tax inspector is in a position to say, well, I take the view that that ancillary hole digging and concreting is just part of the provision of a telecoms mast. But it's all right, because even if I'm wrong on that, you get it under List C, item 22.
Okay, so your hypothetical reasonable tax inspector then is saying, well, it's all right because it's all part of the provision of the telephone mast, and it's saved in by item 7C, and although it may involve works involving the alteration of land, they're all part and parcel of the provision of the structure, so they don't fall within 1B anyway, and even if they do, they're saved by item 22 of List C.
But
So you think, so you're saying there's some kind of de minimis works involving the alteration of land, that even though it's not excluded by list B because it's saved by item 7, it still doesn't fall within 22(1)B because it's a kind of
Good, yes.
de minimis amount.
Yes, I
It's
wouldn't
ancillary.
myself go with de minimis,
No.
but ancillary to the provision of.
Right. Well, that seems to be an argument that I hadn't understood have been raised before either of the lower tribunals. Certainly, they don't seem to refer to it.
I'd certainly addressed the Upper Tribunal on that basis. I think we'd need to go back and look at the written materials that were before the tribunal.
No. Okay.
But I think I.
But that's my answer to the pure point of law on mutual exclusivity.
Yeah.
If you're not disqualified by one, it doesn't mean you can't be disqualified by the other. But there are these cases, as we've been debating, where you can survive via item 7, and you won't be gonged out because there is alteration of land. But even if you would have been, then item 22 in list C saves the day. And that is a coherent structure to these provisions. My learned friend's position, as I understand it, is to say, well, all of this stuff in list B is going to involve alteration of land. Parliament can't have intended in item 7 that if there was alteration of land, you were going to be disqualified. Therefore, list B doesn't disqualify you, and 22(1)B can't disqualify you because it's irrelevant. But that doesn't engage with how 22(1)A, item 7, and 22(1)B work together with item 22.
Can I just, forgive me, see if I've understood what your submission is on the construction of 22(1)B. Is it that works involving the alteration of land is not confined to works which comprise the alteration of land, but extends to works to which the alteration of land is ancillary?
Well, that is the... Until I see where your lordship's going.
I'm not going anywhere. I was just trying to encapsulate what it was that you were submitting on 22(1)B.
22(1)B, self-evidently, disqualifies from being expenditure on the provision of plant. Expenditure on works involving the alteration of land.
Yes.
And it's my submission that that is aimed at the situation where the land is being altered so as to function as plant.
Ah, I see.
So as to create, well, I keep coming back to it, the head race.
Right, but
So-
just is that? I was just trying to think of what works there might be involving the alteration of land which don't result in the creation of any structure or asset. And if one was thinking of building a golf course or a garden or something, you would shift earth around to make dips and lakes and other very flat, I'm sure it's a technical term, but areas, and you wouldn't have a structure, but then you wouldn't have anything that would be described as plant or machinery, but you would use plant and machinery. I mean, you might buy a big digger and skip and things for doing that, but presumably you can claim those as capital Right. So what is it then that is? What is the expense that's excluded if it's not the equipment for doing it? It's the actual expense of using the digger to move the land around.
Yes, well, it could be the expense of earthworks. Part of the problem is that many of the alterations of land which give rise to assets are already dealt with in List B. So a dam, you take your digger and build a dam, dig a hole and heap up the spoil and make a dam. That's already excluded by List B item 4. The reason that this case has been controversial these many years is that the head race, as far as I'm aware, is a unique piece of engineering, and it doesn't obviously fall into any of these categories. We have our argument that it's a tunnel, not least because it was dug in the circumstances you know by a tunnel boring machine and so on, or that it's an aqueduct because that's what aqueducts do.
Yes.
But I'd accept we're at our second level of appeal and there's something to argue about. But there can't be any real doubt in my submission that head race produces what you might loosely call a thing.
I mean, B is evidently aimed at something which doesn't fall within List B. Sorry, subpara B is evidently contemplating something or some things which are not within subpara A, i.e. within List B.
Yes, and it's
so
there.
to that extent, I mean,
yes.
so it could be whatever it is, and the question is, well, does it include a head race?
Yeah. And human ingenuity can produce stuff which the parliamentary draftsman didn't have in mind with List B.
Yeah.
So an automated car wash, which I prefaced in a comment earlier, has concrete formed underground tanks which collect rainwater.
I see.
And a hard standing round which cars drive. And at first instance, the special commissioners in that case, don't look, it's not in the bundle, you don't need to look it up,
Yeah.
but it's called Atwood and Anduff Car Wash. I was in it a quarter of a century ago. The special commissioners in that case said that the whole site, the hard standing, the brick paviours and everything, functioned as one item of plant. That was self-evidently wrong. It was reversed by Mr. Justice Carnworth, and the reversal was upheld in the Court of Appeal. But in order to deal with that sort of argument, in 1994, while that case was still ascending the revenue ladder, Parliament
I see. Yes,
did
I see.
what it did in the Finance Act
All right.
1994.
Okay. Well, I think I understand your point in relation to my telecoms master, which you don't get into little b, because the building works involved are ancillary to the provision of the mast. That's your argument.
That's my
there.
first barrel.
And I appreciate that, but you've gone on to say that actually what B is aimed at is land which is altered so as to function as plant. That's what you said. Yes. All right. Thank you. Yes, I know you're anxious to show us List C as well, and if this is a convenient time, do. But we've taken you perhaps out of your way, but we found that very helpful.
It's extremely helpful to know what troubles the court.
But you move on to what you want to move on to now.
I want to look still at List B, if
Yes.
Your patience extends
Of
that far.
course it has.
What the Upper Tribunal has done is say, well, looking at item 1 in List B, they seem to have a transport flavour. And therefore, they have said, only assets attaching those descriptions which operate as transport items are disqualified. Now, in my submission, that element of noscitur as socis is an inadequate foundation for such a sweeping conclusion. Yes, it is true that the assets are listed like that, and it may well be the case that when the draftsman sharpened his pencil and started listing assets which needed to be dealt with, as soon as he thought of bridge, he thought, what are things like bridges? He said, well, there's viaducts, which might actually be regarded as bridges, or aqueducts. Some aqueducts look like bridges, some don't. So I'll put that in here. But what the Upper Tribunal has done is say only aqueducts that look like bridges are disqualified. And they have not engaged anywhere with the question which leaps from the page: why those and not other sorts of aqueduct? Why transport tunnels and not other sorts of tunnel? And indeed, even internally in item 1, an embankment may or may not have a transport aspect to it.
Well, I mean, the aqueduct of the type we're envisaging, the Upper Tribunal is envisaging, may not have a transport function. So if you've got the Pont du Gard, perhaps the most famous aqueduct in Europe, didn't have a transport function.
The first tier tribunal, I think, would say it transported the water, and that's enough transport.
Well, that's not the sense in which transport was being used, I think, by the Upper
No,
Tribunal.
absolutely not.
But I mean, that's not that's not, okay.
I
mean, so they're in...
Your Lordship makes my point for me. That's the problem with it. So really...
So the FTT didn't confine this list, item 1, to transports of, as it were, people or goods. Is that right? But the Upper Tribunal did. Is that...
The FTT said that tunnel means and means
No, I know
only.
that about tunnel. I'm
Yes,
talking about the whole list.
Yes,
I
may I complete the thought?
Oh, forgive me.
So tunnel means and means only transport
Yes.
tunnels.
Yes.
Aqueduct has a sufficient transport element to come under this umbrella. That is to say, of transporting water.
I thought they talked about canals.
I'm sure they did talk about canals.
Well, I mean, they said canals, or one of them did, which of course a canal is a means of transport. There you have barges going along canals and long boats and so on. But that's not, a canal is included, isn't it, in 3, as we've noted. But a canal is not simply, I mean, in there, an inland navigation including a canal, that's clearly not just a channel of water for the purposes of moving water from A to B. I mean, that's a canal in the ordinary sense of it, that it's...
Yes, but the first tier tribunal found that at least some of these assets were aqueducts. Although the tribunal judge accepted that there was an element of transport function within item 1, he said, well, there's enough of a transport function here, transporting water, to make it into for aqueduct to survive.
Right.
And then he said, well, here are some aqueducts, and then in one of them, the great big cut and cover one, which we'll look at a picture in due course, he said, well, the aqueduct is disqualified, but you can nonetheless have the cost of installing it. But
I see. Yes.
so the Upper Tribunal were remaking the decision, so that's as it were the operative decision in a sense, has said that only aqueducts that look like bridges qualify. And one looks in vain for any explanation for that sweeping conclusion.
Well, but what you're saying is that what we're trying to find out at base, the purpose of all this analysis is whether something is plant or machinery, because the that is what you get the capital allowance.
No, with respect, we're not investigating whether it is plant. We're investigating whether expenditure on the provision of the asset is disqualified from being expenditure on the provision of plant. It would be necessary.
Yes, because
if the
the allowance is supposed to be for plant.
No, the allowance is for expenditure on the provision of plant. So we are dealing with the logically anterior question: is this expenditure disqualified from consideration as expenditure on the provision of plant by these statutory provisions with which Parliament sought to draw the line in the sand? It is correct to say that if the expenditure is not so disqualified, it will still be necessary, would still be necessary, but not today, to determine whether the asset is plant, and in order to do so, whether it functions as plant. But that ship has sailed, and we are concerned with the disqualification of the expenditure.
But all the items in List B are, it's assumed, the purpose of List B, items which are plant or machinery. They're not items which are incurred for providing plant or machinery. They are. I mean, what you're talking about allowing is the expenditure on the provision of a tunnel, or expenditure on the provision of a sea wall or a drainage ditch.
It will be of merely academic interest if these assets were not capable of functioning as plant.
Yes, because this is pushing the debate, kicking the debate down the road from whether it's plant to whether it's actually excluded.
Yes.
Yeah.
I mean, of course, you could read List B, it may not be right to do so, you could read List B as being, as it were, for the avoidance of doubt.
Yes.
Or for the avoidance of debate, shall we say, rather than doubt. I mean, I see your point that if it weren't for List B, you might still have an argument as to whether a sea wall was plant or machinery.
Yes, or car park.
Or a car park, yeah. But anyway, it means we don't need to debate it because they're excluded.
Yes.
Yeah.
I mean, literally, I've spent many, many days before the Special Commissioners arguing whether a car park was plant.
Well, I'm glad to see you're not unemployed as a result of the 1994 Act.
Iron entered my soul a long time ago. But so that before the 1994 legislation, it was at least arguable.
Yeah, well, exactly. Now, I mean, it may be, as my lady says, that it would otherwise be plant or machinery, or maybe, well, let's avoid the debate at all. It's definitely not. Yes.
And let's have a debate instead about whether it's
expenditure on provision definitely doesn't qualify.
Exactly.
Yes, and I'm sure if they try to define tunnel, then they'd debate about whether something fell within the definition. Anyway, yeah. Right, so List B, we're up to aqueducts and tunnels.
Yes, List B item 1 is the particularly exciting one. But is it transport? Well, it has some items which have a transport flavour and some which are less obviously so. Embankment, for example, is the Victoria Embankment a transport asset? It contains the district line, but it also narrows the Thames. It carries roads and gardens and all sorts of things. Is it purely a transport asset? One could clearly argue about it. But the linkage between those items in Group 1 is not, I submit, so obviously transport related as to lead to the conclusion that the only aqueducts which count are ones that look like bridges, and the only tunnels which count are ones that have a transport function. And that's the way the Upper Tribunal went, I submit, clearly wrongly.
But yes, and you were saying that they didn't grapple with why you should only exclude transport aqueducts and tunnels and not other aqueducts.
Given what we know about the purpose, even without looking at the Hansard material, to which one should only have resort in limited circumstances, I completely accept. Even without it, it is, I submit, perfectly obvious from this legislation, taken by itself without the assistance of what the Minister said, that what Parliament is trying to do is to draw a line. And what the Upper Tribunal has done, without explanation, is say that the line excludes transport assets, but not non-transport assets of the same description.
Because what it's saying, you say, is a tunnel or an aqueduct is not plant. Well, no, I don't mean to say that it's not. It's not that the provision of it is not to be regarded as the provision of plant for the purpose of getting the.
No, what they're saying is that the disqualified assets in Group 1 are transport assets.
So that's your point there. You're saying, well, they're trying to derive a common feature from each of the specified items in paragraph 1, which just isn't there.
Yes.
They're not. I mean, unlike, as you might say, little item 2, which is all transport or transport related, item 1 is not, you say.
Yes.
Yeah, I think we've got that point.
And having...
And you say, well, aqueduct bears its sort of full primary dictionary meaning.
Yeah,
And is not restricted to things that look like bridges.
precisely so.
Yeah. Okay.
I'm so sorry.
No, please.
And do you support the First Tier Tribunal's definition in its full width, that it's really anything which is designed to be occupied by water under gravity?
Yes.
So it would include a tap, say, and then you have to go to list C to
Well,
that should be brought in. Well, why wouldn't it include a tap?
It doesn't have that character.
I don't have aqueducts in my bathroom.
No, exactly. It carries water, and you might find a linguistic route or etymological route for it, but you don't say that you fill your bath from an aqueduct, although the water might be brought to a point nearer you by an aqueduct. The new river that starts in Hertfordshire and flows to Islington almost certainly was, and still is, an aqueduct.
No, but forgive me. I'm interested in. I quite understand your submission on aqueduct not being as narrow as the Upper Tribunal found it to be, but the First Tier Tribunal seemed to define it very widely as essentially anything that was designed to take water under gravity.
Yes.
Would it be helpful to see that definition? See where they use that, because I thought they were taking it from the Oxford Dictionary. I may be wrong.
Yes, the tribunal judge looked at the dictionary definitions, and I think it's pretty clear. He also did a little bit of research on the internet, because he gave us some tourist attraction aqueducts as well.
So anyway, where could you just show us where that is? Is it? I've got him on tunnels and things. That's in 66.
It's the FTT decision on.
Oh, it's 68, isn't
68,
it?
yes.
It can mean an artificial channel. That's what the OED says. An artificial channel for the conveyance of water from place to place, a conduit, especially an elevated structure of masonry used for this purpose. So that latter is what perhaps popularly people think of as an aqueduct.
Yes.
That especially bit. But so it's and is that the definition they really accept?
That's the approach the FTT.
The FTT
Yes.
took.
At,
Yes,
at
all right.
69, perhaps, yes. Yes,
69.
I've perhaps mischaracterised it too widely. I see.
Well, yes, I mean, it's a strange thing because the word pipe you would use to describe something that's got a diameter of half an inch or something that's much, much bigger, but an aqueduct doesn't bring to mind something that's very, very small. But what about the overlap between an aqueduct and a tunnel? I mean, the dictionary definition describes it as an artificial channel for the conveyance of water from place to place. But I think that you were saying that even if it's entirely underground, effectively any tunnel which is designed for water to go through is also an aqueduct. It doesn't have to be open to the air.
Yes. And indeed, at 68, we get the benefit of the First Tier Tribunal's research and the reference to the Gadara aqueduct, a subterranean conduit.
Yeah. Yeah.
Thank you.
But then they go on to say in 69 that that has a sufficient flavour of transportation because it's transporting water from place A to place B.
Yes, that's the...
And you say, well, that really is, that doesn't create, you say, that doesn't create a transportation character.
No, but I don't need it. That aspect of the decision is, of course, in my favour. He starts off by, as it were, saying item 1 requires a transportation flavour.
Yes.
And then says there's enough of a transportation flavour in the
Yes.
conveyance of water downhill.
I see. Yes,
But I differ from him in the first stage and say, well, it's transportation, water's flowing downhill. That's an aqueduct. It's what aqueducts are for.
Yeah. Yeah.
Right, but then the Upper Tribunal said it does require a transportation flavour and carrying water from one place to another is not sufficient transport flavour.
And the only sort of aqueduct that counts in this context is one that looks like a bridge.
Whether it's carrying a canal or whether it's carrying water for irrigation. Or
Well,
whatever.
what they actually said was that it's a structure such like a bridge which carries a water course, namely a canal. And as we've submitted in writing, that would render the exclusion of aqueduct in Group 1 totally pointless because canals are excluded by Group 3.
Well, you might have an argument as to the aqueduct which carries the canal is whether that's a canal. I mean, in most people's language, it's not a canal. But, yeah. All right, well, I think we see the points there. So did you want to go to tunnel now, or are we still on the aqueduct?
I have little to say about tunnel that I haven't already said. The First Tier Tribunal said tunnels are for people and vehicles and only them. The Upper Tribunal didn't agree with that and picked up and adopted my observation that that would come as news to those constructing the Thames Tideway Tunnel.
Well, I didn't think that was a very helpful, if I may say so, example. I mean, that may be itself a misuse of language, and it certainly wasn't in the draftsman's mind when they drafted
certainly not
either the
that
94 or the 2002 Act.
But it
I mean, so I didn't...
whether it was helpful or not, the Upper Tribunal, as it was entitled to do, differed from the First Tier by saying the First Tier's restricted view that tunnels must always be vehicle or people, but then reintroduced the error by saying in the particular context of Group 1, they are always transport. So the only tunnels which are
But
excluded.
what sort of, I mean, so to think about this, I mean, let me put it bluntly, why isn't the FTT right about the ordinary meaning of the word tunnel?
Well, it's an available meaning.
Yeah, but what
of the word.
use, leave aside the large sewer, which I think is being constructed under the Thames. I mean, what examples can one give of the ordinary meaning of the word tunnel, which doesn't actually involve the passage of people or animals, I would add, or goods and so on?
The head race.
Well, no, but that's what we're arguing about.
That's
I'm sorry, that won't do, Mr. Brennan.
No, if you take...
No, if you take ordinary language, does not a tunnel always, I would say, involve what the FTT said?
No.
Give me
what
an
about
example other than in
a
this
tunnel
case.
for the particular purpose of carrying utility conduits. List C, item 25.
But that's a
Hold on.
No,
List C.
list C, item 25.
But that's, I'm not sure about that. Tunnels, this is tunnels with a primary purpose of carrying utility conduits,
Yes.
isn't it? And I think you say it's agreed that the words with a primary purpose qualify only the word tunnel. And ducts.
And underground ducts.
Because, I mean, I envisage there, actually, you could have a tunnel which is constructed principally for the purpose of carrying, let's say, cables from one part of a large manufacturing facility to another. But you also want to enable people to work on the cables down there. So you have it large enough to enable people to stand and walk along it. And actually, you could use it as a convenient way of getting from factory A to factory B. But it would still be a tunnel with a primary purpose of carrying utility conduits. What was the main reason for building this thing? It is a tunnel because people can walk along it, but it's not primarily for people walking along it. How does that help you?
Well, because
it is a tunnel because it takes people.
And it takes people, but that is not its primary purpose.
Correct, but what makes it a tunnel is that it takes people.
That, with respect, my lord, that's simply assertion of the.
Well, it is, but why does it say tunnel with a primary purpose? So what they're addressing here are tunnels with a secondary purpose, because otherwise this isn't necessary. So it may be the secondary purpose that makes it a tunnel.
Well, what the FTT said, I don't have the reference immediately to my fingertips, is that tunnels are for people and vehicles.
Well, I'm asking you, why is that wrong? And I don't myself see that 25 gets you out of that problem, because you've got to identify the secondary purpose that may make it a tunnel.
Well, can I?
I don't actually think that does provide you with the answer.
So that it doesn't get lost, could I just tell you about the transformer cable tunnel that we have in this case? It's not under appeal because I accepted the conclusion of the first tier tribunal. But that is a tunnel which takes the high voltage cable off the transformers after the electricity has been generated. So electrically speaking, we are downstream from the generators.
Right.
And that carries this high voltage cable out and at some point it exits the subterranean complex.
That's what goes into the grid, does it?
Yes.
And I mean, what size thing are we talking about?
The tunnel.
Yes.
It's big enough to walk in.
You've walked in it?
Yes.
It's built to enable people to walk in it?
Yeah. Well, it is big enough.
Is there a path or walkway?
Yes, it's big enough to walk in.
So that
Yes.
might be an example of a tunnel with a primary purpose of carrying utility
Yeah,
along,
but it is. That's how
but
it.
a secondary purpose of enabling people to walk along it.
That may well be.
But supposing nobody could walk along it, supposing it was not constructed to enable anyone to walk along it,
narrow.
it's too narrow. If you want to repair the cable, you send a machine
Robot.
down it, a robot. Would it be a tunnel?
Well, I'd say rhetorically, why not?
Well, because that's what we're trying to get
Yes,
to.
but
Why?
if it.
I'm trying to think of a tunnel which doesn't actually involve people or animals or goods walking or being transported along it. The ordinary meaning of the word tunnel. I mean, there are other words like ducts and channels and so on, which might describe other hollows which carry other things like cables and so on. But I'm just really wondering about where one can get a tunnel.
Is it a size thing that a tunnel has to be big enough for a person? Well,
No, it could be a badger.
because a badger or a yes,
Yes,
yeah,
under the motorway. I
yes.
don't know. Yes, I thought the hedgehog. Yes, hedgehogs.
Sorry, would you bear with me one
Yes,
moment? I've lost a
yes.
document and I need to
Of course.
re-find it.
If you need a break at any stage, Mr. Brennan, please say so. We're happy to rise.
Thank you very much, my lord. Don't at the moment.
Very good.
I managed to close my electronic copy of the core
Oh
bundle.
dear, well, yes, yes.
All too easy.
One of the
to
great
do.
advantages of paper.
Well, your lordship gently disparaged my reference to the Thames Tideway Tunnel as being potentially itself a misuse of language.
Well, it might be, but I really don't think that just taking a single thing like that is, with a name with capital letters has been given to it. It's very illuminating.
Well, what about this? I don't make this point on the basis that the taxpayers have made some sort of admission against interest. That would be an amateurish point, and I'm not making it. But we know that all of their terminology, except during these cases, has referred to the tunnel
I see.
as being a tunnel. It was
Right.
dug with a tunnel boring machine. You have in the
Which
authority.
tunnel are we talking about? Sorry.
Forgive me, the particular one I had in mind at that moment was the tail race and head race tunnel, which,
They call them the head race tunnel.
yes,
Yes, right.
and the one that's the 6 kilometre one that's blasted through the rock,
Yes.
not the head race, the other one,
Yes.
is called the aqueduct tunnel. Now,
Yes.
yes. As I stress, I'm not making a point about them.
No. But you're saying,
But
well,
I'm saying
there's a
that
use of language.
This is
Okay.
ordinary
Yes.
terminology
Yes.
by people engaged in this trade. And as you will have seen from the FTT decision, part of the head race tunnel fell down disastrously shortly after it was opened, and it had to be a detour had to be built at enormous expense and delay. And there was litigation about it. You've got in Scotland, you've got the decisions in the outer house of the Court of Session and the inner house of the Court of Session. You don't need to look at them for this purpose. Let me just make the point. Litigation with the contractors called Hochtief. If you just glance through those decisions, they are thick with references to the tunnel. And nobody seems to have said, it's not really the right word for it, It's a circular aperture dug by a tunnel boring machine, but yeah, because it's called a tunnel by everybody who had anything to do with it.
But the vertical bit's called a shaft, so
Yeah,
and if you had something which was solely vertical, you probably would refer to it as a shaft rather
yes,
than a tunnel.
I'm sure you would.
So, but it can't make a difference, can it? Whether it's vertical or horizontal.
I'm not sure a mining engineer would agree with you. A shaft is a vertical or nearly vertical aperture, giving access to whatever's underneath it. And a tunnel isn't. You don't have vertical tunnels or horizontal shafts.
Well, I think you have lots of vertical access tunnels, don't you? But maybe not.
No. But, well, where would a shaft fall within this regime? Are shafts included?
I'll have to look.
Might be an interesting example of a structure coming within item 7. Or not, depending on whether it was within A, B
Well,
or C.
assuming it's not within A, B or C, a shaft would be a structure,
Structure.
not within items 1 to 6.
Yeah. Anyway, so your point on tunnel is, well, look, it's not restricted in the way the FTT said. As a matter of its ordinary meaning, it can embrace the head race, which itself is described as an aqueduct tunnel. That's the point.
No, the head race isn't described as an aqueduct.
Oh, sorry, which is the aqueduct tunnel?
It's
Give me, I got that wrong. I misunderstood.
yes, I'll show it to you on a
Oh, yes,
plan
right.
in due course.
Right, okay.
I'm sorry, it's
Yeah.
not very concisely described. It's a drilled and blasted underground conduit lined with shotcrete.
Yes, right.
That's 6 kilometres long.
6 kilometres.
And
And where you'll show us on the plan. That's fine. But is the I mean, I know we shouldn't be ruled and aren't ruled by dictionary definitions, but what does the dictionary say about tunnel with the FTT quoted?
it's the FTT at 66, I think. I don't think it exhaustively sets out
I see.
the dictionary definition, but you've got some of it. So, core bundle, page 155.
The word tunnel in the OED is defined most relevantly as a subterranean passage or roadway, now most commonly on a railway, also. Sorry, have I got this right? A tunnel in a canal. Okay, mine. The chief current use. Yeah. Okay. Well, they say, well, the OED supports their view of what a tunnel is. The Upper Tribunal, what did the Upper Tribunal say about this again? Meaning of tunnel, paragraph 88. So they say in 90 the FTT was wrong. It's not confined to the transportation of people or forms of transport. It can embrace any form of subterranean passage. And then you said, and you made your point about item 25. And then the Thames Tideway Tunnel. But then they go on to say that tunnel, sorry.
So it's paragraph 94.1, is it?
94.1. I see, yes, thank you.
And so they, having said tunnel can have that wider meaning, they say in this particular context it has the narrower
Yes, in this
transportation.
context, yes, I see. So it's got a wide meaning ordinarily, but the context here gives it the narrower meaning.
Yes. And but the thing that's missing from this reasoning is any illumination of the policy which might lead to that narrowing of meaning. So I'm not sure it's necessary to look it up, but we've got it in the authorities bundle. The Noska Tarasoki's case on which they relied was Pengelly and Bell Punch. That was a case about Section 28 of the Factories Act 1961, which dealt with obstructions to floors and so on. And the Court of Appeal, the luckless plaintiff had fallen over something that was on a floor used correctly as a means of storage. And the Court of Appeal looked at the context in which the term floor was used in Section 28, along with passageways, stairs, and other means of passage, and said that a floor being used correctly as a floor for storage is not within the within Section 28, because it's Section 28 is dealing with obstructions of ways of passage. So there, the court is able to glean from the associated provisions the policy which illuminates the meaning to be given to the statutory term. But no such exercise is carried out by the Upper Tribunal here. They just accept my learned friend's submission that these all look a bit transporty. So tunnel must be a transporty thing. And they don't say, well, why? What is it that Parliament must have had in mind in excluding transport tunnels from allowances and not other sorts of tunnels, or bridge-like aqueducts from allowances, not other types of aqueducts? They just haven't engaged with that.
But does it matter if you've got item 7? Item 7 is intended to sweep up any structure which has not already been listed in 1 to 6, unless it's a structure used for one of those things. Now, if you give a broad meaning to tunnel and aqueduct, then more structures fall within items 1 to 6 than fall within items 1 to 6 on a narrow meaning of tunnel, right? So then item 7 has less work to do.
Yes.
So, but then the scope of 7A, 7B and 7C is much less, because if a tunnel has a narrow meaning in list 1, there may well be lots of tunnels which are used for the purpose of an undertaking for the extraction, production, processing or distribution of gas or telecoms or other industrial things, but it wouldn't then be saved by 7A, B or C because it falls within item 1. So then there might be quite a lot of structure that one would expect to be for the purpose of an undertaking for the extraction, production, processing or distribution of gas. One might think, well, that must involve lots of tunnels.
Yes.
But sorry, they're not carved out of list B because they fall within item 1 and
Yes.
not within item 7.
Yes.
So if you're right that item 1 is broadly defined, it seems rather odd that the carve-outs in 7A, B and C are not expressed more generally as carve-outs from items 1 to 7 and are only expressed as a carve-out from item 7.
But there is no intended carve-out from items 1 to 6. Because item 7 is itself a disqualificatory provision. And it deals only with items which are not within 1 to 6. So once you have a a wider notion of tunnel or aqueduct in item 1. Item 7 doesn't tell you anything about it, because item 7 simply disqualifies other things which are not within items 1 to 6, but subject to the savings in item 7. So there are 7 disqualificatory provisions in list B. Item 7 merely has savings from the disqualification. Items 1 to 6 do not.
Right, but why would you want to disqualify, why would you want to carve out structures in use for the purpose of undertaking extraction, production, etc. of gas, but not any tunnels used for that purpose? Because you would have thought, well, it's mostly tunnels.
It may or may not be. I would speculate, and I'm only doing that in order to
speculating. You yourself said that when you're looking at Pengelly, you have to look at the policy behind this and see why was this carved out. You say, well, they didn't grapple with that, so I'm trying to grapple with
well, if I may complete the thought, there are savings in item 7. So if item 7 had just said any structure not within items 1 to 6, or if the structure of list B had been any structure including in particular 1 to 6, then you would have a wholesale exclusion of structures. The draftsman has taken a different course. He's listed the structures which are specifically excluded in 1 to 6. He's got a catch-all in item 7, but for some reason to do with the electricity industry, the gas industry, the telecoms industries, he has saved those structures. Now that will probably represent existing treatment of structures in those industries, which the draftsman doesn't want to exclude. So that's, I suggest, is the answer to your ladyship's question.
Well, so you say that the electricity lobby was sufficiently strong to get itself this exclusion, but not an exclusion for any tunnels that it needed to make.
That may well be right. Maybe they said, look, you're going to be excluding all of our pylons if you...
where does electricity come in?
Well...
in the meaning of industrial building.
Oh, I see. I see. Right. No, I follow.
Let's stick to gas then,
Yes,
because
yes.
you think of gas as going through it. Well, yes, a tunnel through which gas goes, leave out whether it's actually a pipeline or
well,
not.
I think they'd normally be pipes.
But you might have, let's say, a liquid natural gas terminal. A large part of the expenditure would be disallowed because it would be part of a dock, harbour, wharf, pier, etc. And that wouldn't be saved by item 7. It's simply
one of the
excluded
things
under
which
items
is currently
1 to 6.
litigated is gas caverns. The court might want to be quite careful about what it says about gas caverns. Old salt mines are used for storage of pressurised gas. So there are all sorts of infrastructure assets which might be swept up either deliberately or excluded from deliberate disqualification in these provisions. And they don't, it isn't necessarily obvious what the particular asset is.
Whilst I've diverted you, is what's saved by 7B and C really quite narrow? Because where you have an undertaking whose business is production, processing of distribution of gas or provision of telecommunications, television or radio services, then their structures will probably be saved by 7A in any event. And so what's being saved by 7B and C?
7 is probably not 7A, which
Because
is the definitions of industrial buildings will not generally sweep up collection, etc., extraction of gas or telecoms. Although, if I remember rightly, generation of electricity is one of the trades which qualifies for industrial buildings allowances.
I see.
So you wouldn't want to assume that gas and telecoms is included in the IBA provisions. I don't think it is.
I see. Thank you.
Yes, so is there anything further you want to say about item 1 in list B?
No, I don't think there is. The
Right,
court will
thank
be pleased to hear. Then I need to look, and I'll try to do this quickly because I'm conscious of what I said at the beginning about how long this case would take. There has been a certain amount
We've
of
interrupted you quite a lot.
participation by the court. That's true. Section 23, so that's a general carve-out. So 23.3 says that what we've just been looking at all morning, 21 and 22, do not affect the question whether a list C item is expenditure on the provision of plant or machinery. And we then have a list of items. I think this is in the bundle, is a case called Weatherspoons, which Mr. Justice Briggs accepted my submission, well, assertion really, but it's now in the law reports. The purpose of this list is to preserve the treatment of decided cases on what does and doesn't constitute a plant. Not all of them are, you can't find all of them in the law reports because some of them seem to be items of practice or of unpublished decision, because special commissioners' decisions weren't always published. But there's a case for most of these. So if you look at item 16 in list C, that preserves in aspect the decision of Mr. Justice McGarry in a case called Cook and Beach Station Caravan, where he held that a swimming pool, including its hard standing, the paving stones around it, is an item of plant in a trade of caravan holiday park.
But the first item in list C, machinery, is saying that for the purposes of the general rule which covers plant or machinery, if you are machinery, then you don't have to worry about section 22 because you're always going to be allowable.
Yes.
Right, so section 22 is really dealing with provision of,
Well, section 22 is
difficult to know why they included machinery there. Oh well, provision of structural. Yeah, so machinery is not included in 22.1.
You might find that what the draftsman had in mind was a windmill, and he didn't want a windmill to be disqualified as a structure. So a windmill, which is a device for providing motive power, is preserved even if it would have been knocked out by section 22. And ordinarily, I with respect, accept of course what your ladyship says, you wouldn't, given that it's an allowance for expenditure on a provision of plant or machinery, you wouldn't expect machinery to be excluded. But if you have a piece of machinery which is appropriately described as a structure, then one could see that the point might at least arise for decision, but the draftsman has headed it off at the pass by putting it as item 1 in list C.
Yes.
And I won't do it unless the court wants it, but I can give you other examples. Of
No, I don't know if I don't know if Mr. Peacock agrees that with your proposition about list C.
Absolutely.
He does, so
Yes,
that's
yes.
fine for us. Thank you.
But what's of interest for our purposes in list C is item 22, which we've already looked at,
Yes.
and item 25. Mr. Peacock says, well, these assets should properly be regarded as pipelines. I'll wait for him to develop that. I lost on a pipeline, and I'm going to show you a picture of it. You can see why I lost, and I haven't appealed that. The other things I submit are not, save in the most awkward, strained sense, to be described as pipelines. They're just not. They're conduits or ducts. Of course, what the first tier tribunal did with item 22 was to extend its scope, as I submit, way beyond what it was aimed at dealing with. So, in our prolonged discussion this morning, I've said that item 22 saves the expenditure of digging the hole and putting the concrete in.
Yeah.
That's what it's for.
Yes.
The first tier tribunal, while saying that the point was finely balanced, said, well, you can have construction of the entire thing.
You say, well, that's not installing something, that's constructing it.
Yes.
Yes.
And the point is particularly striking, although not only there, in relation to the head race, because the FTT said that the head race was an alteration. I respectfully agree. Works involving the alteration of land. So it would prima facie be disqualified by 22(1)(b). But then it got back in again on the basis that this was the alteration of land for the purpose only of installing plant, where the plant was the very thing which the works of alteration to land created. So it's a void. And there is some ancillary strengthening because
But
it fell down.
that's a consequence of the oddity of describing a void as plant. I mean, if you're going to describe a void as plant, then it's difficult to know what other meaning to give to installing it more than digging it out. But
it's
you're
not-
saying that you can have some plant that isn't.
You're not
installed.
installing it, you're creating the void. You're not installing a void. You void already. So the Upper Tribunal disagreed with that approach. I submit self-evidently correctly, and I'll not spend more time on it now.
But they said you never got to there because once you fell within 7A, you didn't then have to move on to 22(1).
That's correct. They expressly disagreed with that point about item 22, but they decided against my submissions on that other ground, what I've characterised as mutual exclusivity. Perhaps we could just look at that. Don't turn it up, I know you've read it already, but it's dealt with in my skeleton at some length at paragraphs 38 to 45. It's essentially material on which I have already addressed the court. I now, if I may, want to move on to look at tunnel and aqueduct, and briefly, and I promise it will be, to look at what the Minister said in introducing the 1994 legislation, so as to identify what he said about the mischief.
Right.
Can I just clarify again, because I think I misunderstood it reading the papers, that your case on the application of item 7A, I had thought that it was common ground that if any one of these items does not fall within item 1 to 6 of list B, it would not be brought into the exclusion of list B by item 7 because it would qualify as a structure which is an industrial building.
Yes. That's not correct, because I don't accept that these items are correctly described, at least not all of them, as structures.
I see. But if they're not structures, then they can't be brought in by item 7 anyway.
That's correct.
Right.
So they're not saved by item 7, so we don't get that mutual exclusivity.
Right, but they're not. Right, so if it's not within item 1 to 6, then it won't be caught by item 7, either because you say it's not a structure, or if it is a structure, then it's an industrial building, and so it's not caught by item 7.
Yeah.
Is that
Yes.
right? Okay.
And if your Lordship wants that in rather more precise terms, you'll find it in my supplementary skeleton argument, which was in the core bundle at page 43, paragraph 25 to 130, where I make that point at greater length. May I now take you to Authorities Bundle, tab 39. The Minister, who I think is probably Financial Secretary of the Treasury, Mr. Dorrell. It's Authorities Bundle, as I said, tab 39, it's page 570. It's highlighted. So this is the introduction of the 1994 legislation, consolidated. It looks different, but it's the same thing, in 2001. Unless the court wants me to, I won't read those yellow highlighted passages. 570, Mr. Dorrell observes that the new rules are not intended to change the treatment of assets that qualify as plant. The intention is to clarify and strengthen the boundary between buildings and structures and plant, eroded by a number of court cases which have reclassified expenditure as being expenditure on plant. He refers to the rules, ironically, as providing greater certainty for everybody concerned.
Right, but he also links it to the expected life of usefulness of the asset, because it becoming a piece of plant for which a capital allowance can be claimed enables it to be written off more rapidly than for items with a much longer life.
Yes.
Right.
Now that there,
Is
although
that still the case?
it is to this extent, I've made the point in writing that, for example, assets to do with electricity generation fall more readily within another part of the Capital Allowance Code, namely industrial buildings allowances. Now, I am not making the point that if this is plant, the taxpayers can't have an allowance as plant, because they could get an industrial buildings allowance.
No.
I'm not making that point. What I'm doing is addressing my learned friend's submission for, as it were, sympathy to the effect, well, we should be allowed to get plant allowance for this, and it's nothing to the point that IBAs are available instead. My answer to that is, when you look at the code as a whole, there's nothing unfair about it. These are long life infrastructure assets, and IBAs were available for long life infrastructure assets used inter alia for a trade of electricity generation. The IBA allowance was, as I've put in a footnote in my skeleton argument, a 4% writing down allowance on a straight line basis over 25 years. As the Minister records here, if you get a plant allowance, you're going to write it down at a much greater rate on a reducing balance basis over 7 or 8 years. So these long life assets get all of their capital costs written against tax very early in their life. And that's the protection of exchequer receipts point that he was
Right.
aiming at.
So what he's saying is that a tunnel is going to last 100 years, whereas a pump or a piece of electrical kit, whatever, is going to break down or be obsolete within a much shorter time. So is that one of the guiding principles?
Yeah,
Or what's
yes,
the-
that's what he's getting at here.
Yeah.
But he's also saying we're not trying to move the goalposts for
No, I
things
understand. That's the point
which
to which
are already the subject of court decisions. So, for example, a dry dock has been held to be plant. A dry dock on the Clyde is a piece of plant, although it involves the removal of many thousands of tons of earth and a great deal of insertion of a great deal of concrete. But the House of Lords held in Barclay Curl that was an item of plant and it wasn't disqualified.
But
by
isn't the
this.
point about a capital allowance that you can write it, you can set it, if you like, write off the cost against tax over a shorter period than if it was governed by the economic life of the item?
Yes.
Because otherwise there's no point in having capital allowances. You'd have a single rule which said you write off all fixed assets over their economic life.
Yes,
And that would either be 10, 20, 30, 50 years or something. So buildings are obviously written off over a much longer period by reference there. I mean, that would be the normal accounting thing. I mean,
Yes,
accountants would amortise a capital cost over the economic life of the item.
Yes,
The
but
capital
you don't
allowances
get-
was to encourage people, wasn't it, to invest in plant and machinery, build up manufacturing.
You
and so
don't get a tax allowance for depreciation.
on. No, okay.
So,
I see.
so the Capital Allowances Code
Yes.
gives you capital
But you might get industrial buildings allowance.
Well, that's a capital allowance as well.
Oh, is it? Yes, I see.
So
I
there's
see.
capital allowances are available on all sorts of things.
I see.
And for and at different rates.
I see.
So the IBA code, which is simply in another part
I'm
of
making
the
a
Act,
bad point. I agree. Yes.
gives you capital allowances. It just gives them written down over a longer period for these very long life infrastructure assets.
I understand that in the context of what we're talking about. So, I see. So,
But then
sort
I'm
of
wondering
see.
why,
I see.
whether there's a point that when one is construing the word tunnel, for example, given that all tunnels are long life structures, that might explain why all tunnels and not just transport tunnels should be excluded, so that they don't have the accelerated benefit of
Yes.
write-off.
Ditto aqueducts. So aqueducts is, for the purposes of this discussion, a better point because it parks Lord Justice David Richards' point about all tunnels are transport tunnels.
Yes.
But aqueducts, not all aqueducts look like bridges. So there's the where we know what the policy was to draw the line in the sand and to restrict long life assets from having rapid write-down by way of capital allowance. We know that, but the thing that's totally absent from the Upper Tribunal's treatment of it is any identification of the policy driver which might have led to disallowance of transport or aqueduct, bridge-like aqueducts, and not other sorts.
When you say draw a line in the sand, forgive me, I'm just trying to see what's meant to be on either side of it. Is it what Mr. Dorrell says at the bottom of 570, that the basic distinction is between, on the one hand, buildings and structures, and on the other, plant, and there's been an incursion of plant into the territory which would otherwise be buildings and structures, and the line in the sand is the extent of the incursion to date, that prima facie structures and buildings are to be treated as outside the scope of allowances, unless they've already been the subject of incursion up to where the line in the sand is being drawn.
That is exactly right, my lord. Mr. Dorrell himself, I'm just trying to find it, uses the term draw a line in the sand.
Yes.
It's not my flowery advocacy, it's his. But that's exactly it. So it's to try to preserve the situation. Because there have been cases with swimming pools, dry docks, car parks.
I see. So they would all have attracted some tax relief, but the question is this right, over what period?
Well, they may have done.
Might not have done. Might not have done at all.
Yes,
your point about depreciation not being
electricity generation assets
yes.
Qualified for IBAs.
Yes, yes, right, okay.
But the problem for our taxpayers in this case is, of course, IBAs were then withdrawn anyway, so there's a bit of a double whammy for them. One, even if they claimed IBAs, they'd get them at a much less advantageous rate.
Yes.
And two, they were withdrawn from 2011 anyway, so they were taught for much of the expenditure which they incurred.
I see, right.
So what they want to do is to cram these assets into the category of expenditure on the provision of plant, where, as I would have it, they more naturally fall within industrial buildings allowances. But Parliament took a view about the extent to which IBAs should be available and withdrew them with a timing which certainly affected some of the expenditure which the taxpayer
Right,
incurred.
but you say by withdrawing those, Parliament did not mean that things that used to qualify for those ought now to be regarded as plant.
Parliament had already drawn the line in 1994, long before IBAs were withdrawn. And simply because I said I would draw attention to it, I'll do that. On bundle page 577, in the left-hand column, this is the Hansard.
Oh, sorry, I put it away. Right.
You see the reference to that car wash case.
Right, well...
as an example, which indeed was put to the minister and which he dealt with, and shows you what you might think why he was drawing the line. But I don't want to take up the court's time on it disproportionately.
Yeah, I think maybe.
Made my submission about Noska Tarasokis and Pengeli. And what I take from it, I don't think I need to take the court to it now. Pengeli and Bell Punch is not authority for the proposition that a word of wide meaning is to be given a narrower meaning merely by reason of its proximity to another word.
There's somewhere some authority in the back of my mind where it's been said that nocita asociis is a very weak interpretative tool. I don't know where that is, whether that authority is in the bundle, but
I'm not aware.
I mean, it's quite different from a genus, isn't it?
Yes.
It's almost as if the tribunals were seeking to create a genus. It's occurred to me, actually. Although it's not a very large genus, because of course item 2 is another transport-related genus, but
the particular thing I want to take away from nocita asociis is that where it applies at all, as Pengelly is an example of it, it allows you to identify the underlying policy.
Yeah, no, I follow that.
And we don't have that here. They've just said, well, bridges, aqueducts, they all look much the same, so that must be what it means.
Right, good, thank you.
And then on tunnel, I've drawn attention to item 25. Can I make this submission about tunnel? Tunnel appears in item 1 in section 22 and in item 25 in list C, section 23. They're either in list C, forgive me, let me restart that submission. The draftsman is either using tunnel in 2 different senses in list B and item 25. I say this notwithstanding my discussion with Lord Justice David Richards earlier, because tunnel, according to the Upper Tribunal, is a transport thing, and a list item 25 tunnel is a utility cable kind of a thing. So he's either using it in 2 different senses, as I submit, or if tunnel has a general sense, that saving provision in item 25 list C is redundant, because if tunnels only have a transport function, as the Upper Tribunal held, then they're not, the word tunnel is not apt to disqualify.
Well, that was the point of my question to you, because you could have a primary and a secondary purpose. The secondary purpose being to transport people, so it qualifies as a tunnel for that purpose. But its primary purpose is for carrying utility conduits, so it's taken out. So
yes.
I'm not, yeah.
I mean, with respect, I see your lordship's point. Where the draftsman wants to engage with primary purpose, that's what he does. And it would, I suggest, be an unlikely drafting.
No, I understand. I mean, the contrast is a primary purpose of carrying utility conduits rather than carrying some other type of thing that might be carried in a duct or tunnel. Because I think you're both agreed that with a primary purpose, and I see why, qualifies both ducts and tunnels. They're ducts and tunnels for carrying utility conduits. That's what's...
Yes, there was originally a comma after pipelines. So pipelines or ducts or tunnels.
But yes, right, okay.
That's in the 94 legislation.
Fine, thank you. Yeah. Yes.
Sorry, I've got a half completed sentence. So you say either using tunnel in 2 different senses, or if it has a general sense, then...
A general transportation sense. Oh. Then it's redundant in item 25, because a tunnel being used for a primary purpose of carrying utility conduits doesn't have a transport sense. Now, Lord Justice David Richards would come back at me on that and say, oh no, well, it might have a secondary purpose. But I submit that where the draftsman identifies a primary purpose and said, this is what the thing's for, you don't go grasping around to try and identify a secondary purpose.
Right, but on your reading, tunnel is in list B item 1 is broad, and so one can then rely on item 25 of list C to say, but if the tunnel has a primary purpose of carrying utility conduits, it's saved by.
Yes, exactly. So item 25 in that situation has a purpose because it takes out of the disqualification in list B item 1 the tunnel, because you might need the tunnel, as in our particular case we did, where we had the transformer cable tunnel, which was allowed by the FTT, and which we don't challenge.
Well, unless tunnels might be caught in item 7 and need to be taken out. Well, let's not.
Well, the FTT did not find that the tunnels are structures.
No, that's...
Then moving on, just to make one point on aqueducts, we are, I submit, entitled to the benefit of the first tier tribunal's finding of fact on what is an aqueduct. I accept that if, as a matter of law, aqueducts must look like bridges in this context, this argument is not available to me. But if I'm right about aqueducts generally as not being just bridges, but also all sorts of conduit, then I have a finding of fact that these items were aqueducts. I don't have a finding of fact in my favour that the head race is an aqueduct, because the FTT said about that its function is far more complex. It was specially designed, they say, to deliver the right amount of water at the right pressure, and that somehow disqualified it from being an aqueduct. My answer to that is that it was designed to move water downhill under the influence of gravity. And what the FTT has done is confuse complexity of design in an engineering sense with function. And the physical function was to move the water downhill under the influence of gravity, and that's what aqueducts do. So the FTT should have held that the head race was an aqueduct. And I've submitted in writing, I don't think we need to go to it, the proposition that once the legal parameters of a statutory term are identified, whether the particular asset falls within those parameters is a question of fact. And the authority for that, there are doubtless lots of others, is a case called Clark and Perks, where I was on the wrong side of the question whether a jack-up drilling rig was a ship.
Right. Commercial court case.
The pauses are because I'm making progress through my notes, not because I'm not. So yes, my ground 3 is the head race, the tail race, and subsidiary tunnels, which there's a dewatering tunnel, a drainage tunnel. Nothing turns on their different nomenclature. They have the same character as the head race and the tail race. So I contend that they are tunnels or aqueducts, as we've set out in our scale of 55 to 58. So that's the legal position. May I use the last 5 minutes to show you some pictures? It's a bit of light relief.
Yes.
It's in my unagreed bundle, no longer controversial. I'll just take these in order, if I may, and just comment on them as we go. So at page 1, we have a diagram which you've seen elsewhere, showing it's a schematic diagram from the reservoir down the head race, through the turbine, and out into Loch Ness.
Who prepared this diagram?
This is the taxpayers' side, I think not prepared for the purposes of the litigation. It's an illustrative piece of publicity at some earlier stage. But it's accepted that this is what it looks like.
Thank you.
We can just notice that on the far right-hand side, flowing into the reservoir, and this is only a schematic, obviously, we've got an aqueduct.
Yes.
Then coming down from the reservoir, the head race is described here as the power tunnel.
Yes, I see we have a shaft as well. No.
Yes, indeed. Not an issue, I think.
No,
because
no,
it's part of the dam.
Sake
and,
of completeness. Yes.
the legislation did at least have the arguing about the dam and the reservoir.
No,
So
right.
how does the water get into the intake tower?
I think someone in a control room in Perth presses a button and some sluice opens.
It doesn't get in at the top, I think.
It doesn't get in at the top, no.
Right.
I think if the water gets up as high as the top, it is probably drained through the head race and generates a great deal of electricity until it gets down again. But I'm not sure about that. It may be spilled over the dam. But Lord Justice Popplewell's answer is the main one. It doesn't go in through the top.
Right.
Then one can just notice the main access tunnel,
Yeah.
which is not controversial. But,
Because that is presumably for people and being...
yes, but it's part of the premises and it didn't qualify as plant. And it hasn't been appealed. The next page simply shows some of the repair work after the... It does show elements of repair work after the head race tunnel collapsed. The bypass and so on. I'm not going to keep making the point, but it's thick with references to tunnels. The next item, unfortunately small print, is in reverse order. It's 2 pages, entitled Scheme Statistics. If your bundle's numbered the same as mine, it's page 4. It gives you the catchment area of 75 square kilometres, output, the head of water is 608 metres. Then at D, details of the head race tunnel, TBM driven tunnel diameter 5 metres.
Mm-hmm.
TBM is a tunnel boring machine. It went up the mountain, inside the mountain, and the spoil obviously was ejected downhill behind it. Bypass tunnel, tail race tunnel, and so on. The aqueduct tunnel, you'll see this again in a minute. That's when on page 3 under G. The aqueduct tunnel, drill and blast tunnel, approximately 7.8 kilometres, comprising cut and cover sections totaling 1,000 metres, and drill and blast sections totaling 6.8 metres. Then reference to the power cabin and the access tunnels, including the transformer cable tunnel, which I've already mentioned. Page 5 details about the tail race tunnel. carries water from the power station down to the loch. It's not under pressure by now. Its energy has been spent having come through the turbine. At 5, you begin to see some of the gargantuan scale of some of this stuff. So this is the cut and cover conduit cast on site in reinforced concrete. The FTT held, and this is the subject of the procedural appeal, which is the last of my points, held that this was an aqueduct, but nonetheless said that under item 22 they could have the cost of only installing it, when in fact, of course, it was constructed on site. It wasn't installed at all in any meaningful sense of the term. It was made. Then there's a schematic overview. What I've got is page 7. And you will see on the right-hand side a pipeline identified, not controversial. You're going to see a picture of the pipeline in a minute. Then there's a long straight red line labelled the aqueduct tunnel. That's the 6 odd kilometres of drill and blast tunnel.
So where is Loch Ness? Is that the...
It's top left-hand corner diagram. Just the end of the loch, which is of course long and thin. The tail race tunnel discharges into the loch.
Oh.
The lake-like thing in the middle is the reservoir.
Yeah.
I see. Yes. Right. Yeah.
But what's this snake like? That's not Loch Ness.
It's not. I don't think it's anything to do with the case.
Oh.
I think it's probably a lake. I'll be corrected at some stage if I'm wrong. If you start off with the reservoir now, you see the head race tunnel. It's got a kink in it, which I think was the result of the bypass after it fell down and had to be redone. The head race tunnel falls by 600 metres over a distance of 6 kilometres, discharges through the power, can't quite read it, power something, house I think, turns the turbine, and then the water comes out through the tail race tunnel. So it is literally the same water going down the head race tunnel as comes out of the tail race tunnel.
Well, shall we resume looking at these at 2 o'clock? Thank you very much, Mr. Brand. 2 o'clock.